Welcome to the Innovation, Business, and Law Center Speaker Series. I'm Jason Rantanen, professor at the University of Iowa College of Law and director of the Iowa Innovation, Business, and Law Center. Today, we welcome Danie Schwarcz, the Fredrikson Byron Professor at the University of Minnesota Law School. Professor Schwartz researches and writes about insurance law, with past work exploring constitutional questions in insurance regulation, discrimination by proxy, and systemic risk. He's the recipient of the American Law Institute's Young Scholars Medal and the Liberty Mutual Prize for his work on property and casualty insurance law. His work has been published in journals such as the Chicago Law Review, Virginia Law Review, and Journal of Empirical Legal Studies, and he's testified to congressional committees on insurance matters. In his submission for the Innovation, Business, and Law Center Prize, Professor Schwartz observed that discrimination is fundamental to the business of insurance, and proposed to explain how the antiquated legal and regulatory regime for insurance has produced systemic racism in insurance markets, as well as what law and regulation can do to help reverse these trends. I'm now going to turn it over to Professor Schwartz. We'll talk for about 30 minutes. After that, we'll have some time for questions and further discussion. Welcome, Professor Schwartz.
Hello, I'm really pleased to be here, and I'm going to share my screen. And okay, so hopefully you all are seeing now my PowerPoint, which is what should define the future of insurance, anti-discrimination law, and regulation. So with that, let me tell you what I propose to talk about today. So here's my basic plan. I'm going to start off just by giving you a brief primer on insurance discrimination, why it happens and how it's regulated. Then what I'm going to do is explain to you why I think our current regulatory regime, legal regime, has some real problems with it. So I'm going to talk about how that regime ignores the impact of insurance practices that actually do potentially exacerbate systemic racism, and how it can actually promote a particular form of discrimination known as proxy discrimination. From there, I'm going to suggest some solutions, and I'm eager to hear what you think during, I think we'll have 10 or 15 minutes at the end for some Q&A. So that's the basic plan. So let's get to it. So first, let's just start off talking about insurance discrimination. So in many ways, insurance really is the business of discrimination. And insurers discriminate in a lot of ways. They discriminate in terms of how much they charge you, in terms of whether or not they'll give you a policy, in terms of what type of policy they give you, in terms of which subsidiary they place you in. Why do they do that? Well, a lot of it actually is quite necessary. So when I say that insurance is the business of discrimination, I don't mean discrimination in a pejorative sense. I mean it in terms of classifying people. And insurers find it necessary in competitive marketplaces to discriminate, because if they don't discriminate, then what ends up happening is a variety of problems can occur, where either people don't take care because they feel like they have insurance, or where people who are particularly high risk are more likely to go and purchase insurance. So by calibrating premiums and coverage to the perceived risk that is posed by an individual, insurers can limit these problems of adverse selection and moral hazard. And just more generally, they can promote care. If at the end of the day, your insurance premiums are linked to how careful you are, that's going to give you an incentive to actually be more careful. And it might even give you an incentive to be more careful than you would be if you didn't have any insurance at all, because you're getting some more information via the adjustment of your premiums via insurance. So insurance discrimination is absolutely necessary in the insurance setting. Now, historically, insurers had a few different criteria that they would use to try to discriminate and sort of predict risk, and that's what they would discriminate on. But increasingly, insurers are getting more technologically sophisticated about how they discriminate, and nowadays it's becoming increasingly common for insurers to use complex algorithms, artificial intelligence, to actually accomplish their goal of segmenting policyholders based on risk. Moreover, the data for this discrimination increasingly doesn't just come from your insurance application. That's where it used to come from. You would write down certain facts about yourself, and the insurer would take that into account. But more and more, it's coming from these sort of third-party external vendors. So the sort of traditional, the most long-standing example of this is insurers relying on credit providers, providers of credit information to actually price policy. So just like your credit score might affect how much it would cost for you to take out a loan, it also might affect your insurance premiums, because insurers would buy access to that information from third parties and then use it to predict risk. Okay, so insurance, as I mentioned, is the business of discrimination, and at least some types of discrimination are fundamentally important and necessary in most lines of insurance. At the same time, there are obviously legal restrictions on how insurers can discriminate, because not all forms of discrimination are tolerable. So the most basic form that we have is in virtually every state, there's a statutory prohibition on what's called unfair discrimination. And that's the extent of the statutory term. But that term, at least in the insurance setting, is generally understood to mean discrimination that's not based on price, or on risk, excuse me. So to the extent you are twice as risky as some other person, it wouldn't be unfairly discriminatory for an insurer to charge you twice as much. By contrast, it would be unfairly discriminatory if the insurer charged you 3 times as much. So that's the basic idea of unfair discrimination and the prohibition on it. States devote a lot of resources actually to checking whether insurers are engaging in unfair discrimination, principally through a regulation and regulators reviewing filings to make sure that insurers' rates correspond to risk. Now, in addition to these prohibitions that are on sort of a prohibition on non-actuarial risk-based discrimination, there are also prohibitions on specific insurers using specific factors to price coverage, even if they are actuarially justified. So the extent to which these prohibitions exist depends on the state, and it depends on the line of coverage. In Iowa, in auto insurance, it might be prohibited to use race, but then in a second context, it might actually be that there is no prohibition on, for instance, using age in life insurance, okay? So it really depends on your state and on your line of coverage and on the characteristic, what's prohibited and what's not. Perhaps not surprisingly, the use of race, ethnicity, and national origin are usually prohibited in most lines of coverage. And even where they're not explicitly prohibited, I think most people think that they are implicitly prohibited. But what does this mean, this prohibition? Well, what this actually means is that, at least as enforced by state insurance regulators, because they're the only entities that can enforce anti-discrimination law against insurers by and large. In general, unlike, say, in employment law, we don't have private causes of action against insurers. Well, the way that regulators understand these prohibitions is, look, you can't explicitly take into account one of these factors, so I can't ask you what your race is and then plug that into my formula to try to figure out how risky you are. And I also can't intentionally try to accomplish that by using an obvious proxy. And we're going to return to this idea in a little bit, but this arises out of a rather unsavory history in the insurance industry and also in the credit industry of something you might have heard of, which is called redlining. So when insurers and banks were prohibited from explicitly taking into account race to price their products, many insurers and banks would intentionally try to define via an actual red line historically minority geographic regions, and then just say, we're not actually discriminating against people on the basis of race, we're just discriminating against them on the basis of where they live. Well, where they lived was just an intentional proxy for race, and so that practice has generally been understood to fall within the scope of these prohibitions. Okay, so this is the historical practice. But of course, times are changing. And so here we have just a new committee formed by the NAIC, which is sort of the overarching body of state insurance regulators. There's some complex issues about how it's formed, but I won't get into that right now. And you can see that the time here, they literally just met a few days ago. They just formed, and they are looking at ways of trying to fundamentally rethink how insurance law and regulation addresses systemic racism. So this is not just a theoretical topic. This is obviously a topic of great practical importance where, at least ostensibly, state regulators and lawmakers are trying to move forward. Well, why might they be trying to move forward? So the first major issue that I want to talk about is sort of implicit in this regime that we described here, which is this regime basically says the following: so long as you use a characteristic that's not race or a national origin or whatever it is, sex or sexual orientation, you can use that factor if you can show that there's some correlation between that factor and risk of loss, whatever it is. And that's the approach. And the problem with that approach, or at least one set of problems that I want to discuss, is that there's overwhelming evidence that a large number of factors that insurers use in different settings, in fact, disproportionately harm people based upon their membership in a protected group. So for instance, auto and homeowners insurers will charge you more money or refuse to insure you based upon your driving record, your credit score, your zip code, your occupation, and increasingly an almost infinite amount of data. And putting to one side the infinite amount of data, all of these factors are well known to correlate with race in the general population, well known to correlate with income. We can think about your driving record, for instance. On the one hand, it makes sense. If you have a ticket, maybe you should be charged higher auto insurance premiums. On the other hand, if you're much more likely to be pulled over by a cop because you're African American than if you're white, then what's going to end up happening is that African Americans are going to have higher insurance premiums than whites, or less access to auto insurance. And if you don't have access to auto insurance, you might not have access to a car. And if you don't have access to a car, or at least legal access to a car, you might not be able to work or get around. Similar thing with homeowners insurance. If you don't have access to homeowners insurance or you're priced out of it, that might mean you can't buy a home. So insurance is not just something that we don't want people to pay a lot for, but it's a means to an end, and really in allowing people to participate economically in our society. And it's not just auto and homeowners insurers. Life insurers too discriminate on all sorts of categories, and some of which we know empirically are highly correlated with protected classes. So you can take criminal history, for instance. There's extensive evidence that people are much more likely at every stage of the criminal justice system to be treated differently on the basis of their race. And so what ends up happening is that life insurance becomes much less available or much more expensive for African Americans disproportionately than for whites. So that's the first thing that we just want to think about and acknowledge: disparate impact. And right now, insurance regulation does not even consider whether or not a disparate impact occurs based upon these factors. So long as they are not themselves race or ethnicity or whatever else, and there's some correlation between these factors and risk, insurers are allowed to use them. Now, there are a variety of reasons why we might think that's problematic. Here's the first one. It turns out that even though ostensibly there's a prohibition against unfair discrimination, meaning non-actuarially justified discrimination, the way that that's actually enforced is oftentimes limited. And there's increasing evidence that not only are minority zip codes, for instance, charged more for auto insurance, but they're even charged more for auto insurance when there aren't larger aggregate losses. So I think the ProPublica study mentioned here is worthy of a discussion for a minute or two. What the ProPublica study found was that individual insurers within several states that they were able to study were systematically charging higher insurance premiums in predominantly minority zip codes. But what it also found is that, at least at the aggregate level, there were entire auto insurance claims in those predominantly minority zip codes relative to predominantly white zip codes. So they, on one hand, found that many insurers, not all insurers, but many insurers were charging much higher rates in those areas. And then at least when they looked at an aggregate level, they found that there weren't higher claims. And I'm going to come back to this in a little bit because some of the limitations of this are a result of the data and the limitations in the data that's available, which is ultimately the focus of where I think needs to change. So the first thing to recognize is it might be that there are actually real differences in the rates that people are charged, disparate impact, based on factors like driving history, right? Like you're charged more because you're pulled over more because you're African American, but you're not actually more likely to get into a car accident, okay? It just might be that these historical categories we have that we thought intuitively were linked to claims are not as linked to claims as we thought. It might be that there are some other things at work here. So there is some good evidence that at least some insurers have practices that effectively attempt to charge more to consumers if they are less likely to comparison shop. So most people, they just renew their insurance every year. They don't think about it. They don't price it once they decide on who their insurer is. They have a tremendous amount of loyalty, and then their insurance rates go up at a gradual pace, and they sort of don't ever realize it. And insurers love those consumers because they can increase rates relatively quickly, even if those increases don't correspond to increases in risk. And there's at least some evidence that, again, demand elasticity, or the extent to which you comparison shop, correlates with race or income for a variety of difficult to explain reasons. Okay, so one reason why we might really be concerned about disparate impact then, just to sum this up, is it might be that certain types of disparate impact aren't actually really needed for us to get all these good things that I talked about from insurance discrimination, right? When we go back all the way over here, we said, look, insurance discrimination is so necessary because insurers have to price based on risk. If they don't price based on risk, we get adverse selection, we get moral hazard, all these terrible things happen. But if it turns out that actually these disparities aren't related to risk, then all of a sudden the reason for tolerating this disparate impact evaporates, okay? So that's one important point to really appreciate. A second point is this. Even to the extent, and this is sort of classic disparate impact analysis, even to the extent that there are some insurer practices that simultaneously have a disparate impact, but are also important to predict risk, it might very well be the case that there are better, less discriminatory alternatives available. So for instance, insurers increasingly are getting better at individually assessing risk based on your actual practices, as opposed to grouping you with other people and trying to derive your risk from that approach. So for instance, auto insurers are now increasingly measuring how safely you drive with these devices on your smartphone or other devices. And that is less discriminatory and potentially better at assessing risk because it's not grouping you with anyone else. It's just measuring you. Okay, now that doesn't mean there aren't any problems with it. There might be. But the point is that even if we were to say, on the one hand, risk-based discrimination is fundamental and important and we need to discriminate on the basis of risk, and on the other hand, it's a problem that there's a disparate impact that no matter what, even if it has these good insurance benefits, it also is going to harm social and economic mobility, which is sort of a, I take as just sort of an axiom that we want to improve socioeconomic mobility. It might be that there are ways we can have both of those, right? So that's the other question that right now insurance law and regulation at least just don't explore. So that's one set of issues that we can come back to. Now, the second set of issues I want to talk about involves what's known as proxy discrimination. And this is a particular concept that I've actually written about in the Iowa Law Review, actually with a professor at University of Iowa, Anya Prince, who many of you may know or be familiar with. So what's the idea of proxy discrimination and unintentional proxy discrimination? Well, let me first start off by giving you the technical definition. The way that I define proxy discrimination, it's used loosely in a lot of different settings, but the way that Anya and I define it is as follows. One, it's a practice that produces a disparate impact. But it's not any practice that produces a disparate impact. There has to be a second characteristic as well. And that second characteristic is that the usefulness to the discriminator of a facially neutral practice derives from its capacity to proxy for membership in a protected group. Now that second part of the definition is difficult and sometimes a bit sort of hard to explain. But I want you to think about it like this using our traditional redlining example. So as I mentioned, insurers, when they were first told that they couldn't discriminate on the basis of race, they still wanted to. And so how did they do it? They just chose a proxy. They said, you know what, instead of using race, we'll just use where minorities live, okay? Now that fits the definition of proxy discrimination because we had obviously a facially neutral practice, i.e. geography, that disproportionately harmed minority groups. But it wasn't just that. It was also proxy discrimination because the usefulness to the discriminator of using the geography was actually because of the fact that geography was linked to race. So that's sort of intentional proxy discrimination that I think a lot of us can wrap our heads around, okay? But it turns out that proxy discrimination can also be unintentional, at least under this broader definition that I've laid out here. And the reason for that is whenever a characteristic or a trait, let's take race, okay, is predictive of something that the insurer cares about and is facially neutral. They care about claims. If race is facially neutral, if race is predictive of claims and there's a facially neutral characteristic that proxies for race, then what's going to happen is that insurers, when they use that characteristic, are going to find that it helps them predict claims, and they're not necessarily going to know why. And so whenever there's some rational discrimination, by which I mean statistical correlation between prohibited class, membership in a prohibited class, and something insurers care about, i.e. claims, then even if an insurer doesn't necessarily intend to discriminate on the basis of the protected characteristic and doesn't even know that they're doing so, to the extent they rely on a proxy for it, they're going to find that it's predictive. So I think this can be visually presented with this diagram here. So what you will see here, and let's see if I can get my pointer. All proxy discrimination is a form of disparate impact, subset of disparate impact, right? And this is sort of intentional discrimination. Sometimes you can do something intentionally that also has a disparate impact as well. But proxy discrimination can be either intentional or unintentional. So for instance, intentional discrimination is redlining. But unintentional proxy discrimination is where an insurer just uses some characteristic, let's say credit score. And they say, I don't know why it works. I mean, it's a little bit funny. Why should your credit score predict how likely you are to get into a car accident? Insurers know it works, and there's good evidence it works. But why? Well, one answer is maybe it predicts how responsible you are. But what if the way it works, the reason it works, is that race actually predicts the extent to which you're likely to have a claim, and credit score is correlated with race. In that event, an insurer might, without even knowing it, be engaging in unintentional proxy discrimination. So let's take another example that I think I can intuitively motivate a bit more. We know that race is correlated with life expectancy. There's a lot of research to that effect, and it's very clear in the literature that that's true even after we try to control for other factors. And traditionally we say that's because of systemic racism, right? Like there are all sorts of ways we can't measure in which African Americans are treated worse in terms of the provision of health care, whatever else, that in the aggregate have this effect on their lifespan. Well, if you're a life insurer, that has major implications for you. Race matters in predicting claims if you're a life insurer. But life insurers are prohibited from considering race for good reason. Why? Because we have all sorts of reasons why we don't want intentional discrimination against people who are African American. It will end up, exacerbating systemic inequalities. It will end up making savings less available to communities that have been mistreated in the past. So we prohibit it, even though it looks like it would predict claims. Well, what can a life insurer do? A life insurer say, oh, well, I just discovered credit scores predict life expectancy. I don't know why, but it does. But what if they start using credit scores and the only reason it predicts life expectancy is because of its correlation with race? Then effectively what the life insurer has done is just found a new way to discriminate and target people because of their race. And so that's unintentional proxy discrimination. And the argument that Professor Prince and I make is that that is normatively troubling, what I just described to you, in a way that goes beyond ordinary disparate impact, because it effectively reproduces the results that would come to fruition if there were intentional discrimination. So if insurers can just proxy for race, even if they don't know they're doing it, life insurers are using credit scores, they don't know why it's useful, but it turns out the reason it's useful is because it correlates with race, which itself predicts life expectancy. Then we're effectively reproducing a world in which life insurers can price based on race. And we might have all sorts of objections to that, right? And it's not just about exacerbating systemic inequalities. It's also about saying, well, maybe the reason African Americans have lower life expectancy is they don't get the same resources. Their communities, when they go to healthcare providers, they don't get the same attention because of discrimination. And we're actually sort of making those inequalities worse by then saying, aha, now you get charged more for life insurance, or you don't have access to life insurance so that you can't maintain wealth over generations. So this is a real normative problem, I think, in a way that's different than ordinary disparate impact that I was describing earlier. So for that reason, I think we need to think about it more. And one reason I want to sort of highlight that I think we particularly need to think about it is, before I sort of came up with this example, oh, well, a life insurer might just use credit score and not know why. But as I mentioned earlier, insurers are increasingly using artificial intelligences to actually price and rate coverage. And all an AI does at base, in a very sort of simplified way, is scour a tremendous amount of data and just try to find correlations between all sorts of data points and the thing you tell them to care about. So if you program an AI and you say, look, find me policyholders who are least likely to actually make a claim, and here's a ton of data, the AI is going to do that. Now, the law is going to not allow you to tell the AI what people's race are, what people's any other prohibited characteristic. But to the extent that a prohibited characteristic is in fact predictive of the thing they care about, as I said, we know for all sorts of reasons we can't explain that race is predictive of life expectancy, then inevitably, it's not just sort of it might happen sometimes, inevitably what AIs will do over time is come up with variables that are predictive of the thing they care about, i.e. life expectancy, because they essentially piggyback off of race. They capture the predictive value of the data that the AI has been deprived of. Maybe it's the magazines you subscribe to. Maybe it's the Facebook chats you're a part of. Maybe it's the people you follow on Twitter. But those factors will inevitably become part of what the AI considers. All right, so how do we deal with this? These are difficult issues, and I don't want to pretend that they're easy, but I do want to tell you that there's an easy first step. And the easy first step is data. Right now, the fundamental problem about why we don't know exactly how often these things are happening, and I had to sort of say we have evidence of this, we have evidence of this, we don't have good data. In particular, states do not make available data on premium. All you really need is a very simple set of data: premiums, claims, and zip code. Okay? Premiums, claims, and zip code. If you had that by individual insurer, Okay, so State Farm, in this particular zip code for auto insurance, this is how much it charges in premiums in the aggregate. This is for whatever type of insurance, and these are the claims in the aggregate. Then at the very least, you could start answering questions like, okay, are people in predominantly minority zip codes charged more for insurance? And in particular, are they charged more because they have higher claims? So going back to the ProPublica study, the reason it was ProPublica that did this and no academic is because an academic wouldn't have published what ProPublica published. Why? Because it was deficient. But why was it deficient? Because they didn't have access to good data. The only data, they were able to get data on the amount of premiums that were being charged to different people by basically just getting lots and lots of, doing lots and lots of quotes. But what they couldn't get access to were the ultimate amount of claims broken down by insurer. They could only get it at the aggregate level in 4 states, okay? And the difficulty there is they said, well, here's what we see. We see that insurer X, insurer Y, they're charging more in predominantly minority neighborhoods than predominantly white neighborhoods. And in the aggregate, there are not higher claims in these predominantly minority neighborhoods compared to predominantly white neighborhoods. Well, what's the problem with that? The problem with that is maybe for the individual insurer, the aggregate statistics don't hold true. So the insurance industry had a ball with this, talked about how incompetent it was, and it wasn't incompetent. Basically said there's smoke there, but I can't prove there's fire. And the reason I can't prove there's fire is because there's not data. So the first thing we could do is make that type of data available. Insurers have successfully resisted this for years by saying, oh, this would reveal trade secrets. And it's just baloney. It's baloney that simply forcing them to reveal premiums and aggregate claims by zip code would in any way allow competitors to infer trade secrets. It just doesn't make sense. There's not a good argument for it. Now, I think we need to go further. And I think what we actually need to do is do something like the Home Mortgage Disclosure Act. And what the Home Mortgage Disclosure Act at a federal level does is it requires all mortgage providers to report in a centralized repository data about individual transactions. Did I make a mortgage or not? On what terms? And also to report, was the person I made a mortgage to identify as a minority, identify as someone who is low income, whatever else. And there are a bunch of different, by nationality. Now, you're not required to fill this out if you're getting a mortgage, but you're asked about it. And you're asked about it so we can look at the effect that mortgage providers' practices have on the availability of loans, because that matters. Well, we should do the same thing in insurance. We should collect information so that we can tell, not just, so the zip code level data is okay because we can sort of guess what people's race and income are based on zip code level aggregate census data. But it's not that effective compared to just getting that data directly. And there's really not much of a barrier to doing it, except for the fact that the insurance industry refuses. And they are incredibly influential at the state level. In fact, I mentioned this regulatory project. It's not going to go anywhere because of this, unfortunately. So what's really needed is a national movement to establish a uniform national data reporting repository that is very similar to the Home Mortgage Disclosure Act, that publicly discloses each insurer's de-identified policies by policy type, by claims, and by race. Now, that will, again, get you to be able to figure out disparate impact. To figure out proxy discrimination, that's harder. And I don't think that can be done while also revealing non-confidential information. But what can be done is to require insurers to report confidential information to regulators who can then test for proxy discrimination. And there's a relatively easy, at least theoretic way of explaining how you test for it. All you do is you say, well, you discriminate on the basis of occupation and education to get claims. Great. Also tell me the race of the people that you are discriminating against, and let's include that in a statistical analysis. And if it turns out that once we include race, all of a sudden education becomes an irrelevant factor because it was just proxying for race, then we know you're engaging in proxy discrimination. So it really just takes sort of a statistical familiarity with regression techniques, and it can be done with data that, while you can't I am sympathetic to concerns that we couldn't just reveal all data about exactly how every insurer prices products. That data can be made available to regulators, and it's not right now. And the final thing I'd say is we should consider a private cause of action. Now, I think that obviously different people are going to have different reactions to that. There are people who favor more litigation-oriented strategies and those who don't. There are problems with it. But I would just point out that there are ways to develop a disparate impact cause of action that can respect the importance of discrimination in insurance. For instance, you could just have a presumption that to the extent that reliance on a facially neutral practice predicts risk, that is a legitimate business purpose. So there are ways of doing this. I'm not wedded to that idea yet, but I think it should be on the table. And I certainly think that at the very least, we're not going to be able to even start the conversation about these problems unless we measure them and figure them out. And if we don't have the data, we can't do that. So that is the conclusion of my presentation, and I am very excited to hear your thoughts.
All right, well, thank you, Professor Schwartz. So what we're going to do now is we're going to open it up for questions. And the easiest way for you to ask a question is just to type it into the Q&A function in the webinar, or you can write the question into the chat. What I'll do is if it's a really short question, I'll just read it. If it's a longer question, I'll unmute the person who asked the question, and you can ask the question yourself. So while people are getting started thinking of really challenging questions for you, I have one, which is when you talk about some of the national level reforms that you're proposing, what is there an ideological aspect to this? In other words, is there like, you know, Republicans are going to be totally opposed to anything in this space, or so can you talk about the political economy aspect of it?
Yeah, and this is where I struggle the most, because there absolutely is a huge ideological element to it. And the ideological element is, to some extent, as you suggest, which is that Republicans deeply resist any national regulation of insurance. Their sort of standard line is that state insurance regulation works great. It's better to regulate locally. And even a lot of Democrats are on that page to some extent. And we have a long history of state insurance regulation. And my view is generally we should defer to state insurance regulators if they're getting the job done. But there are certain areas where they're just not getting the job done, or where there are good reasons to believe that we need a national solution. And we do have certain national insurance statutes. I mean, the most famous being Obamacare, which applies to health insurance, but there are others as well. There's a Terrorism Risk Insurance Act. There's a variety of others, that, you know, Flood Insurance Act that we have. And so I think that the information collection that I'm imagining, I'd be good with it if it happened at the state level. I'm encouraging states to do it. And I think some states can, but I've gotten so frustrated at, frankly, the level of influence that insurers have at state legislators. The influence that insurers have at state legislators is astronomical. And actually, one sort of interesting reason for it, from a political economy perspective, is there are unbelievable number of state legislators who are also insurance agents. It turns out that those jobs work really well together, because a lot of times they're both part-time. And so you know, you have a part-time legislator, and the other half of the time you do your insurance agent. And by the way, what do you do as an insurance agent? You know everyone, right? And you sort of are your face is plastered on the sign. And so there are just a tremendous resistance in most states to real reform, or even really engaging with these issues. I mean, these issues are not new. So part of why I advocate a federal response is because I think the political economy is easier there, even though it's harder. But then the other reason is, look, if you're trying to build in structures for collecting data, it's just, especially if you have national insurers, it's just much more efficient to have a national uniform system where you define the data in a certain way, you collect it in a certain way, you make it available in a single space. Part of the problem right now is states are different. I mean, the vast majority of states don't disclose anything. There are a few states that disclose something, but all of those states are a little bit different in terms of where you get the data, how good the data is, how far back it goes. None of them include lost data by individual insurer, which is really sort of which is a pretty fatal defect in my view. So I think we need a national solution, both for political economy reasons and for reasons relating to efficiency and practicality. And how likely do I think it is? Well, I thought it was more likely a few months ago. The politics are changing on this, but I think that to the extent we are really having a national conversation about addressing systemic racism, a huge part of that has to be the insurance industry, because the insurance industry is, as I mentioned earlier, I mean, these products are necessary for people to engage in modern commercial activity, driving, owning a home, saving money for and protecting your children and your dependents. All of those are fundamental to sort of promoting socioeconomic mobility. And so to me, it's a pretty fundamental part of the conversation. But whether or not those political forces are going to be able to, overcome the resistance people have towards regulation, is a question. And I, if you're gonna ask me how optimistic I am, that's hard to say.
All right, I have a question here from Professor Prince. Can you talk a little bit about how we can address the trust issue where those of protected classes may be more likely, and for good reason, to be skeptical of sharing their data and having insurers have access to their protected trait?
Yeah, so this is a really good, important question. So as Anya well knows, in certain contexts, we're just not going to be able to do it. So one of the, well, Anya and I wrote about proxy discrimination generically in insurance, less focused on sort of systemic racism. And a big problem is, say, like proxy discrimination for genetics. Like we have a prohibition on the use of genetics, even though it's like super predictive of things that insurers might care about, because we ultimately want people to be able to get genetic tests. And there's just, it's sort of an intractable problem to sort of say, oh, well, just give us your genetic data too. And then we'll sort of test for whether the effect of this practice is to harm people with a certain, genetic traits. On the other hand, I think increasingly people are willing to share data about their race, ethnicity, national origin. I will point out that people do that all the time for mortgage documents, right? I mean, this is an established practice that's been established since the 70s, where part of the application process is you check a box. And you don't have to fill it out. I mean, you can choose not to indicate your race, and that's fine. But it's not something that anyone thinks sort of discourages people from getting mortgages or creates these big problems of, oh no, they're asking me what my race is to discriminate against me. I think it's worked out okay. And I think people have an increasing awareness that the reason why we collect that data is not nefarious. It's actually to assess systemic racism. Because if we just pretend that race doesn't exist, we just pretend that everyone is just the same, that's when systemic racism actually is most likely to occur, when we're not trying to look for it. Because a lot of it is not intentional. A lot of it is people not thinking, and people acting based on stereotypes and based on implicit biases. And so if you don't sort of actively question that and look for it, you're gonna have worse problems. So I think that's my answer. I realize it may not satisfy everyone, but I think that the successful track record we've had in the mortgage space should lead a lot of people to think that this is a reasonable approach.
All right, we have time for one more question. This one's from Joe Valenti. So Joe, you want to unmute yourself and ask your question?
Sure. So this was fantastic. Certainly learned a lot. I'm curious with regard to individualized technology for rate setting, things like the telematics in cars. How can that be audited to make sure that we're not replicating similar correlates? The case that always comes to mind for me is, the driver that I might have in New York or Los Angeles is going to be driving aggressively because everybody's driving aggressively. Is that not replicating some of the same kinds of concerns?
So I think it's a really good question, and I don't know that I have a perfect answer. But what I guess I would say is I think that there are different types of concerns, right? Because let's say that you're just measuring, how aggressively people are driving. it is true that that's going to differentially impact people depending upon where they're driving. But there's also a way in which there's a direct cause and effect, I think we can say, between what is being measured and losses. Now obviously causation is sort of a difficult thing, and I don't want to get too far, but like I think we can like pretty clearly see the direct correlation. Okay, if you're driving aggressively and stopping and starting a lot, and there's a direct correlation between that, and not just a direct correlation, but sort of a causal relationship between that and your likelihood of getting into a car accident and having a claim. And I think when we can see those causal relationships, I mean, with full recognition that as any law student knows who's taken tort law, causation is a difficult issue, and it's not just, but when we can see what looks like intuitively, we can tell a pretty intuitive causal story, I think that a lot of these other concerns become less significant, because we're not operating through a proxy, right? Proxy discrimination occurs when the reason why X is predictive of Y is because it operates through some other suspect variable. And so there is no proxy in that case. It's just direct, oh, you're driving more aggressively, you get into more claims, that's it, right? So having that more causal connection helps. And then also in terms of disparate impact, I worry less about disparate impact because we're not judging you based on your membership in a group. I mean, that's ultimately what insurance does right now. It judges you based on your membership in a group. And that's where disparate impact becomes a real concern. And I don't want to say that there's no disparate impact concern in the type of setting you mentioned, but I find it much less concerning in a way. I mean, I don't know if in fact, if we use that technology universally, if in fact, we would see different outcomes for different groups, and, I can't say it wouldn't happen, but to the extent it did happen, we could say, well, yes, but it's not really about the insurance, it's about something else. And right now, I don't think we can say that in most insurance settings where insurers are basically just trying to measure risk by putting you into groups of other people who are somewhat similar to you.
Well, thank you, Professor Schwartz. I really appreciate your talking to us today. So what we're going to do now is we're going to wrap it up. Join us next week for Audrey Savage of the Emory School of Law, who will be talking about Beyond Aunt Jemima, holding public companies accountable for dismantling systemic racism. So I hope to see you all then. Have a great week.
Thanks so much.